Okay, so as I said, the purpose of this webinar is to talk about how to handle dealing with applicants who present with a criminal history, and this is applicants that you're actually interested in, the ones that you're actually considering offering a position to. So I want to just start with a quick poll, and I'm going to ask you this question. Let me also go down to my next slide. So I just launched the poll, and the question is, what is the estimated number of American adults with arrests or convictions in their past? Is it 20 million, 45 million, or 70 million? So just go ahead and give your answer to the poll question. Did I not launch it? Now I launched it. I'll just wait until most people have had a chance to vote. Okay, so we're at 84% of you have voted, and the majority of you are responding that the answer to this question is 45 million. And actually, the answer to the question is 70 million. And that is data from, I believe it's the Poverty Law Center. It's information that was included in a press release from our governor's office about ban the box. So 70 million Americans have arrest or conviction records in their past. That's a lot of people. It's a lot of potential applicants, and it's a huge impact on the country as a whole if those people are not afforded employment opportunities. And there's data that indicates that people who have a criminal record that they earned before they were 23 have a much higher likelihood of living in poverty for the rest of their lives as a result of that. So it's a big number. So we kind of kick around the term ban the box. Ban the box was a national campaign to remove criminal history questions from employment applications with the idea that people would have a much better shot at employment if they were considered as an actual person as opposed to a checkbox on a form. So Vermont is actually the 7th state in the nation to sign on to implement a ban the box provision. The policy objectives of ban the box are summarized in a press release that is in one of the links that I sent you in the chat. So in the chat, I sent you some information, including a link to our policy, but also a couple of articles that have been issued, one of which was a press release from a year ago. And that press release summarized our goals for Ban the Box as really threefold: to prevent discrimination, because a lot of times, as you may be aware, even just from recent news, there's a lot of evidence that there's a disproportionate impact on people of color in the law enforcement process. That a lot of people with who are Black or Hispanic may be more likely to receive criminal charges and be convicted than white counterparts who did the same thing. So one of the goals is to prevent discrimination. One is to reduce barriers to employment, because if people aren't given an opportunity just based on the fact of a simple answer, have you ever been convicted, yes or no, they may actually be well-qualified applicants for the position that they applied for, and we're trying to reduce that barrier to employment for them. I'm sorry, I'm just looking at one of the questions that we got. Yeah, we'll get to that, Helena. Another policy objective, which is a larger social objective, these are all larger social objectives, is to decrease the risk of recidivism and incarceration. Obviously, if you don't have an opportunity to obtain good employment, you're going to be in a much more difficult position when it comes to actually trying to live a law-abiding life. So those are all pretty high-level policy objectives that are more about us as a society and our role as an employer in that society. Obviously, as an employer, we are also required to not implement or practice policies that would have a discriminatory impact. So the governor said about this, too many Vermonters with criminal records are unable to successfully re-enter their communities due to lack of employment. Banning the box is all about breaking down barriers and giving those Vermonters who have paid their debt to society a fair chance at finding a good job. Nobody wins when Vermonters are trapped in a cycle of unemployment and incarceration. So in a nutshell, that's why we're doing that. Apologize, I'm just working with Michelle on the questions for a second. Hold on. Okay, so we're back. Sorry about that. So as I alluded, we've done a couple of things already in Vermont to follow this policy of banning the box. Basically what banning the box means is that we don't ask on the application form at the time of initial application, we don't ask a question of applicants such as, do you have any felony convictions or do you have any criminal history? So a little over a year ago, the governor signed an executive order that instructed Human Resources to implement a policy to prevent us from screening applicants up front, screening out applicants up front solely to their criminal history. The intent was to give qualified applicants an opportunity to explain their record. And we do make exceptions, of course, for those positions where there's a particular criminal history that would be disqualifying due to the requirements of the position. So our policy that we did implement a year ago essentially moves the box to a later stage of the process, and we're going to discuss that more in the next slide. And then next year, in this past session, the legislature passed a law that will be implemented July 1, 2017, in which all Vermont employers will be covered by provisions similar to the ones that we are already following. So we'll be compliant because we're already doing what the new law requires.
We worked with the legislature to try to make sure that it harmonized. We're successful in doing that, so we shouldn't have two different standards.
So we issued a guidance memorandum last year when we implemented the new policy, and I included that guidance memorandum in the documents that I shared with you in your GoToMeeting panel or your GoToWebinar panel, so you should see those documents there. So we have a guidance memorandum that I shared with you. For some reason, I'm not seeing the documents now.
They're up when this is up. What was the shape that? It was on before you came on it.
So I shared with you the guidance memorandum, the declaration form that we use, and also the executive order. So in our guidance memorandum, what we did was we implemented a criminal history declaration form. So that criminal history declaration form just basically asks applicants the same questions that we asked on the application in the past. So it's the same information, we're just obtaining it at a later stage. And what we are doing is getting that information only from people that we've identified as top candidates and that we are actually seriously considering for employment. So we don't ask everybody, we only ask the candidates that we are actually interested in. So in the guidance memorandum, we say that it would be once those top candidates have been identified and after the first interviews, if any. And we're also instructing in that guidance memorandum that the criminal history declaration form goes from the applicant to your human resources administrator as opposed to back to you. And the whole reason for that is just to keep it kind of more neutral. The criminal history declaration form is unrelated to any background check requirements. So if you're a department that has a background check requirement in general or for specific job classes, you're still going to follow that process. The guidance or the declaration form is separate and apart from that, just like the application was. So it's unrelated to that. You still would do both. So the big part of the guidance memorandum and the main thing that Michelle and I wanted to cover today is to talk about this concept of an individualized assessment. The individualized assessment is terminology that's used by the Equal Employment Opportunity Commission when they talk about this issue. And basically it's got three parts to it. One is that when you do have an applicant that you have deemed qualified for your position, and you then have the information that they have some sort of criminal history in their background, there are three factors that you're going to consider. One is the nature and gravity of the offense that the person committed. So what did they do? The next is the passage of time. Like how long has it been since they did that? What's happened in the meantime? You might also consider how old they were when the offense happened compared to how old they are now. And then the third factor of the individualized assessment is job relatedness. So is there some connection between the thing that they were convicted of and the job that you are filling? And one thing I want to clarify here is we are talking about convictions. We do not consider arrest records when we are evaluating an applicant's criminal history. We are only concerned with convictions. People may be arrested, and those arrest charges may have no merit, so and may be found to be, you know, may not result in any further action. We do not act on arrest records.
I would say on the individualized assessment too, this is it's not really ban the box. Ban the box just tells us not to ask the question on the initial application, but we're still left with that question of what do we do with the information once we get it? And I think this is also relevant to what background checks you do. You know, sometimes you'll get a result of your background check, and then managers will want to know, what does it mean, and what can I do with it? And the individualized assessment is a guide for what to do with that information. You know, the idea is, of course, that unless it's absolutely disqualifying by law, then you would do this individualized assessment to see if it really is necessary to disqualify the person or if they could still have the job. So it's a way of evaluating that information. And we do on the, I think Gail's answering a question right now about corrections. You know, when we decided which agencies could maintain the box, those were the agencies that had the automatic disqualifiers. So corrections has some automatic disqualifiers based on PREA requirements. VSP had some based on ability to carry a gun. So there were some agencies, very few, that had an exception to ban the box. Everyone else is going to have to move the box and then perform the assessment afterwards.
And I would add that with corrections, for any of you that are here from corrections, there is still an individualized assessment component to the corrections process. So corrections still asks misdemeanor and felony screening questions on the application itself, but they have a waiver process which would accomplish the same thing as the individualized assessment. So the concept with the individualized assessment is that we're taking a holistic look at what the person's entire background is, because we've already said they're a suitable candidate for the position. We've already said that they're one of our top candidates for the position, and now we're just evaluating this new information the same as we would with reference checks to determine if we're going to proceed to offer or not. So what this does, by removing it from the application, moving it to that later stage of the process, is it gives them that opportunity for explanation to discuss kind of the context of the offense and what they've done since then that might mitigate against it. And our general policy guidance is that we would exclude them from further consideration only if doing that would be necessary for the safe and efficient performance of the job. So it's very much a job-related criteria. When we talk about the opportunity for explanation, I think some hiring managers have indicated to me that if somebody, maybe if they're not finding out about the criminal history record until kind of this later stage of the process, that somehow is an indicator that the person, that they would have concerns about the person as a result of that. I don't know, Michelle, if you want to comment on that.
I mean, if somebody who discloses up front, that's helpful, because you would know earlier, of course, and there's maybe an indication of additional honesty or being forthcoming. But if no one asked the question and you didn't answer, I don't think that should be held against them either, as long as they do fill it out honestly when they fill out the form. And then on the form, there's a section where they can explain the circumstances, and you can either just consider that, or if you want to engage in a further conversation, you can do that too.
So I mentioned the EEOC, and I wanted to come around to that now and talk about that a little bit. So we have our own basic expectations about how we want to handle this process, but we're also operating within a larger national framework as an employer where we want to be acting in compliance with the Equal Employment Opportunity Commission. So what they tell us, in addition to providing us with that individualized assessment protocol, is pretty much the same as you would see with any other discrimination prevention requirements that they have. One is to apply the same standards to everyone. So we would not want to have, we wouldn't want to treat people differently based on any protected categories that they might be a member of. We need to not have policies and practices that have a disparate impact. And disparate impact is kind of a, maybe a little bit of a mushy concept, where there are requirements that an employer might have that would unfairly screen out segments of the population who don't have the same, I'm trying to think of, just where statistically they may not present with some of the same opportunities as others. So for example, you might notice on a lot of our job or a lot of our minimum qualifications now, where we used to require a high school diploma, we now will most often say a high school diploma or equivalent, because there may be a disparate impact on certain segments of the population where those folks who grew up in poverty or other disadvantaged circumstances may not have been able to get their high school diploma in the traditional manner, but they were able to get a general equivalency diploma or complete trade school or something like that. So that might be an example where if we stuck to the high school diploma, we might be running afoul of the disparate impact concept.
I would add too that disparate impact, you don't need to have an intent to discriminate. It's just it's the result. So you actually made the decision based on a criminal history, but if that impact of that sort of decision does have a disparate impact or a higher level of keeping out people of a certain race or color or any protected class, then you have a disparate impact, even though you had no intent to discriminate against the person on that basis. So you're still held liable for it. So it's hard to get there. I will say it's hard to get to disparate impact, but if we apply these principles uniformly, then we won't get there.
And so the third concept from the EEOC is that we want to ensure that our decisions are job-related and consistent with business necessity. So that comes back to that concept of really looking at what the job-related requirements are. So before we move on, we have a couple of questions that I do want to address. One is that the question is it human resources staff that take a look at the individualized assessment factors, or does the hiring manager do that analysis? And so I would say that we would hope that that would be kind of maybe in partnership. Ultimately, it's the hiring department's, the appointing authority's decision, and we would like to have the opportunity to consult with you on that before you make that decision.
And we get calls a lot of times from managers, you know, I've got someone with a 2-year-old DUI, how do I handle that? We can talk you through the factors and the things to consider, and it's a lot of times come down to a matter of judgment, but we're happy to weigh in.
I want to kind of hit a couple of scenarios. We have a few minutes left in our presentation, and I want to make sure we kind of get to this. So I have a poll that I'm going to share with you on this. And so the scenario here is that we have Pat as a finalist for a position that involves authorization of state payments. So you can kind of fill in the blanks for a position that you might be familiar with that does that. And Pat, unfortunately, has a criminal history that includes petty larceny. So would you say that Pat is automatically disqualified from further consideration for this position, or should an individualized assessment be conducted? And I'm going to launch a poll to ask you this question. So this is for a position that involves handling financial records, authorizing state payments. I don't have a particular position in mind, but let's see what most of you say. So most of you are saying yes, an individualized assessment should be conducted, and we absolutely agree with that. Michelle, is there anything else that you would want to offer on this particular scenario?
Well, I would say, for example, if you're the tax department, they are not allowed to hire anyone. They have an absolute ban on anybody who has a conviction for a crime of this nature, so a financial type of crime. If you're not that kind of an agency, then you should do the individualized assessment, because what if maybe the petty larceny was when she was 20 years old and shoplifted. She's now 45, been an upstanding citizen ever since. Should that really be held against the person? So the individualized assessment's key to deciding, you know, is it something that should be excluding or not? And if you otherwise think this is the best candidate, then why not? Why not? You're always taking a bit of a risk, but you just have to judge whether or not it's worth it. And I think in a case of shoplifting 25 years ago, that's probably worth it. But it will all be based on the facts of your particular situation.
So I do want to respond, I guess, or raise one of the questions. I'm not sure we have an answer for it right now, but the question is, people can be imprisoned without conviction while they're awaiting bail or whatever. So what does that mean in terms of the criminal history declaration form? And should that fact that they were imprisoned without a conviction, should that be held against them in this process?
And yeah, the answer is no, because conviction is the standard. Being held without bail is not the standard. It's conviction.
Let's try another scenario. So in this one, we have a candidate who was involved in gang activity in his youth, and he served time for a felony assault charge as a result. Now he's 45, and he is the top candidate for an administrative position in a State Department. So the question that I'm polling you on is, what information would you be looking for to assess if his offer of employment should move forward? So I'm just going to launch this poll. And so the questions are, you'd be looking at, the possible responses are, you'd be looking at the circumstances of his criminal offense, how other staff would feel about working with him, his history over the past 20 to 25 years, his age at the time of the offense, or the type of position and department that he's applying to. And this is a multiple choice question. poll is fun to look at because it's got nice colors on our side. Okay, so about 75% have voted. We're getting up toward 80. So this is good. So I would agree with the majority of you, where you absolutely want to look at the type of position and department that he's looking at. 81% chose that. His age at the time of the offense is a relevant factor. His history over the past 20 to 25 years is even more relevant. The circumstances of his criminal offense are also relevant. Sometimes the raw data itself doesn't tell you as much as knowing kind of what happened around that. And then most of you did not select how other staff would feel about working with Joe, and we would agree with that. That's not a valid consideration here. It's not part of the standard that we're looking for. So, so we're largely in agreement. Is there anything that you wanted to add on that, Michelle?
No, I think all those factors are really important to consider, and again, it's just a case by case. What's the job? You know, any crime 25 years ago with a completely clean record since is going to be kind of hard to hold against someone. But put yourself in a position now, maybe it's 10 years ago or 5 years ago, then it's going to maybe pivot in another direction, especially if it's something dealing with the public or something where we're concerned about assaults. But I think the passage of time, and especially in an assault kind of case, is important.
So let's do one. We have time for one more example. Whoops. So this is Susie Q. Sue is 35 and a finalist for a position that requires occasional client transport. 13 years ago, she had a DUI conviction. And she says now she's received treatment for alcoholism. She's been sober for 10 years, went back to school, and got her degree in human services. And what information would you be looking for to assess if her offer of employment should move forward? So I have one last poll I'm going to launch on that question. So would you be looking at the circumstances of her criminal offense, her history since then, her references, the safety of clients and potential liability for the state if she were hired? Or would you say that she shouldn't be offered the position based on this history? Okay. Got a lot of votes. About 85% have voted so far. So 45% would consider Sue's history since the offense, and certainly that would be an appropriate part of an individualized assessment. Nobody has chosen the circumstances of her offense. Might or might not be relevant.
Could be relevant. I think the degree maybe of intoxication you might want to consider, although 13 years ago it's maybe less, but you could find a situation where that, maybe where there was an injury or things like that, maybe could make it better or worse. But again, 13 years ago, she's been in treatment, all that sort of thing really weighs very strongly in her favor.
So 13% would choose her, would rely on her references, and I do think that that would be one of the important factors that you would look at. And then 22% each said that you would consider the safety of clients and potential liability, and also 22% said, no, I don't even think she should be offered the position. I think that's kind of a no-brainer. So I don't know if you have anything you want to comment on with that, Michelle.
I'm surprised at the last one. I think we have to consider the factors in this case just like any other case. It's not an automatic disqualifier by law, so it shouldn't be an automatic disqualifier here. I think it's at least in the spirit of the ban the box legislation, and is that we will at least consider those factors. Now maybe you'll decide, no, I don't want anyone who's ever had a DUI. I've seen this one come up a couple times now, and I've heard people talk about liability to the state. As long as you're making a reasonable decision based on reasonable facts, you don't need to be concerned about liability. but you should certainly consider safety and things like that. It just all comes down to a reasonable assessment of the facts that are before you. But I think in her case, you certainly should at least consider them.
So that was our quick review of how to handle a review of an applicant's criminal history. I hope that you found it helpful. If you have, let me just check and see if we have some more questions. If you have other questions, if you have some other questions after the fact, you should please feel free to reach out to your HR administrator, or certainly Michelle's office would also be available to assist you. I guess I didn't make that last question multiple choice, so I'm sorry for locking you in on choosing just one factor. I'll fix it for the next session next time. So please do let us know if you have any questions after this session, and we hope that you found it helpful. Have a great afternoon, everybody.